I invited my son into my home, and he used the invitation as a blueprint for theft. He sat at my kitchen table for 2 years, ate my food, slept in my spare room, said he loved me, and then he filed paperwork to take the house out from under me while I was still living in it. He told me, very calmly, very deliberately, "You'll be dead soon anyway, Mom. You might as well make it official." I said nothing. I watched. What Dennis Ray Whitfield did not know, what he could not have anticipated, was that the woman he dismissed was not the woman he was dealing with anymore. Good day, dear listeners. It's Clara again. I'm glad you're here with me. Today's story comes to us from Margaret Eleanor Whitfield, 75 years old, a retired English teacher from Roanoke, Virginia, and she says she is ready for the first time to tell this exactly as it happened. I have lived in my house for 31 years. I want you to understand what that means before I tell you anything else. Because without that understanding, the rest of this story is just a legal dispute. It is not a legal dispute, it is a life. The house sits on a wide corner lot in the southwest corner of Roanoke, Virginia, 2 stories of pale yellow clapboard with a wraparound porch that my late husband, Gerald, built with his own hands the summer before he retired. There is a white oak tree in the front yard that Gerald planted the year our youngest, Dennis, was born. And I have watched that tree grow from a sapling no taller than my knee into something enormous and permanent and shading. Every spring, the kitchen fills with the smell of the wisteria that climbs the east side of the porch, and in the evenings, when the light comes through the back windows, the whole downstairs turns the color of warm honey. Gerald passed in 2017, and I will not pretend the years since have been easy, but I stayed. I tended the garden he started, I maintained the house. I paid the property taxes on time every single year, and after his estate cleared probate, the deed to that house transferred to my name alone. I owned it outright. No mortgage, no lien, no encumbrance of any kind. 3 appraisals conducted since 2019 placed its value between $640,000 and $680,000. It was my house, my most meaningful asset, my home. My son Dennis Ray Whitfield is 49 years old. He is the younger of my 2 children. His sister Pauline lives in Oregon, and we speak on Sundays. Dennis has always been the one who needed things, jobs that did not last, relationships that unraveled, a business venture in 2018 that cost him and his former partner a great deal of money that I never fully understood and never fully asked about. I am his mother. That is the trap of it. You love them because they are yours, and sometimes that love prevents you from seeing them clearly. He came to me in October of 2022. His apartment lease had expired and he had nowhere to go. He was quiet about it and somewhat ashamed, which seemed sincere at the time. I told him he could stay in the spare room. 3 months, I said, just until he found something stable. He nodded. He thanked me. He carried in 2 duffel bags and a box of books, and I thought, this is what mothers do. I made him dinner. He sat across from me at my kitchen table and talked about his plans, and I believed him. The way you want to believe someone you have raised. 3 months became 6, 6 became 12, and then the second year began, and something in the house began to change in a way I could not immediately name. He started asking questions. How old was the original deed? Had I updated my will recently? Had I considered something called a life estate? I answered him honestly, as I always had, because he was my son, and I did not yet know what the questions were building toward. That was my mistake. Not the love, the honesty. It was a Tuesday in November, the 2nd Tuesday of the month, which I remember because I had just come back from my book club at the Roanoke Library. I set my purse on the entryway table, and Dennis was standing in the kitchen doorway with an expression I had not seen on his face before. Not angry, not nervous, but settled, like a man who has already made a decision. He held out a document, a multi-page document, printed and paper-clipped, with a yellow sticky note on the front that said, in his handwriting, "Sign here, here, and here." I took it from him slowly. I did not put on my reading glasses right away. I looked at his face first. He was watching me with that settled expression, patient, like I was a problem he had already solved. I put on my glasses. I read the first page. It was a quitclaim deed. A quitclaim deed, transferring ownership of my house, the pale yellow house on the corner lot with the white oak tree in the yard, the house Gerald built the porch on with his hands, transferring it from Margaret Eleanor Whitfield to Dennis Ray Whitfield as sole owner. I felt something cold settle in my chest. Not panic, something heavier and quieter than panic, something that sits below the ribs and stays. "What is this?" I said. I did not say it like a question. It's the smart move, Mom. Dennis Ray Whitfield said, if you transfer it now, we avoid a long probate. Pauline doesn't contest it. You still live here. Nothing changes for you. Nothing changes, I repeated. You're 75, he said. The house is going to pass to someone regardless. This just makes it clean. Dennis, I said. I put the document down on the counter. Who prepared this? He said a notary had prepared the form. A notary he knew. I said I wanted the name of the notary. He gave me a name I did not recognize. He said I was overthinking it. He said it again. You'll be dead soon anyway, Mom. You might as well make it official. I did not raise my voice. I did not cry. I said, I will not be signing this today. And I picked up my purse from the entryway and walked past him and up the stairs. I sat in my bedroom with the door closed and the document in my hands, and I read every line of it 3 times. My hand did not shake. I was deeply, carefully, deliberately afraid, but my hand did not shake. And by the time I finished reading, I had already decided that fear was not the response that was called for. I did not sleep in my house that night. I called my daughter Pauline in Oregon. It was late for her. Past 10, and I told her what had happened in short, clear sentences. She cried. I did not. I told her not to call Dennis. Not yet. I told her I was going to my friend Ruth Ann's house for a few days, which I did. Ruth Ann has a small guest room with a blue quilt and a window that faces the neighbors' rose bushes. And I sat in that room the next morning with a legal pad and a cup of coffee that had gone cold. I allowed myself to cry once, briefly, fully, and with my face in my hands. For Gerald, because he would have been devastated. And for myself, because I had opened my door to this. Then I set down the grief. There was no room for crying in a plan. I made a list. The deed. The property tax records going back 5 years. Gerald's estate documents from the probate in 2017. Any financial records showing Dennis's residence. Any written communication where he referenced the house, the transfer, or the notary. I also wrote down the name, Patricia Ann Holt, which I had found in the Roanoke Bar Association directory the night before on my phone. She was listed as an estate and property litigation attorney at Holt and Carmichael Law Group on Jefferson Street. I had read 2 reviews from former clients. Both used the word thorough. That was the word I needed. I called Holt and Carmichael the following morning and had an appointment by Thursday. Patricia Ann Holt is a composed woman in her early 50s with close-cropped gray hair and a habit of writing in a legal pad while you speak, which I found immediately reassuring. Her office on Jefferson Street is small but organized, a wall of shelved binders, a desk with 2 monitors, a framed quotation on the wall that reads, "Facts are stubborn things." I told her everything. I brought the quitclaim document, the original deed in my name, Gerald's probate paperwork, and a folder of 2 years' worth of financial statements from my checking account showing that I, not Dennis, had paid every utility, every tax installment, every insurance premium on that property. Patricia Ann Holt read the quitclaim document without expression. Then she looked up and asked me one question. Had I signed anything? I had not. She set down her pen. Then you are in a strong position, she said, but we need to move quickly. Over the following weeks, Patricia Ann Holt and her associate at Holt and Carmichael filed a declaratory judgment action to confirm my sole ownership of the property and established the quitclaim document as fraudulent. She subpoenaed the notary. Dennis had named a man called Terry Osborne operating out of a strip mall in Salem, and obtained a sworn affidavit from the Roanoke County Clerk's office, confirming that no valid transfer instrument involving my property had been recorded. She also filed for a temporary injunction barring any transfer, encumbrance, or alteration of the deed while the matter was pending. The injunction was granted within 6 business days. Meanwhile, I gathered everything on my list. The property deed in my name, recorded in 2017 following Gerald's probate, 7 years of property tax statements, all paid from my account. My homeowner's insurance policy naming me, and only me, as the insured party. A letter Dennis had sent me in 2022, before he moved in which he described himself as looking for a place to stay temporarily, which established that he understood his occupancy as a guest, not a I also found, in the bottom drawer of Gerald's old filing cabinet, a letter Dennis had written to his father in 2014, asking Gerald to transfer the house to him directly. Gerald had written back, and kept his own copy saying, and I am quoting exactly, "This house belongs to your mother. Whatever comes after that is her decision, not mine, and certainly not yours." That letter would become the most important piece of paper in the entire case. Patricia Anholt labeled each document, numbered each exhibit, and built a binder that was, by the time it was finished, 2 inches thick. The first call came on a Monday morning, 3 weeks after I had retained Patricia Anholt and moved back into my house. Dennis had not lived there since the night I declined to sign. He called from a number I did not recognize, and I answered because I expected it. "Mom," he said, and his voice was different, tighter, slower, like a man who had been advised. "I think we should talk about this like adults. You're making this into something it isn't." I said, "Dennis, my attorney at Holt & Carmichael has been notified that you may contact me. This call is being documented." A pause. "Then, you've got a lawyer." "Over a conversation, over a quitclaim deed," I said. "Good morning." And I ended the call. I said nothing further. I watched his next move. His next move came through his own attorney, a man named Barry Fenwick, who sent a letter to Patricia Anholt offering a settlement. The letter proposed that I allow Dennis Ray Whitfield to be named as a on the deed in exchange for $120 to be paid over 5 years, and a formal agreement that he could remain in the house rent-free for 24 months. Patricia Anholt called me the morning she received it. She read it aloud. When she finished, she asked me what I wanted to do. I said, "I want to decline." She said, "I agree completely. But tell me why." I said, "Because $120,000 is not the value of my house, because co-ownership means co-control, because Dennis Ray Whitfield has not paid $1 toward that property in 31 years, and because that letter does not address the quitclaim document he had prepared in my name without my knowledge or consent." I declined. In writing, through Patricia Anholt and Holt and Carmichael. The third confrontation happened on a Wednesday in February, in the parking lot of a Panera Bread off Williamson Road, which Dennis had suggested as a neutral location, and which I had agreed to because Patricia Anholt said my attendance was optional but might be useful. I went. I sat across from Dennis Ray Whitfield at a corner table with my coat on and my hands folded, and I waited. He came with his girlfriend, a woman I had met twice, who sat to his left and said nothing the entire time. Dennis started with nostalgia, the house, his childhood, his father. I listened. Then he shifted. He said Pauline had agreed with him privately that the house should come to him. I knew this was false, because Pauline and I had spoken the night before, and she had authorized me to share her written statement with Patricia Anholt, which I had already done. He said I was being manipulated by an attorney who was billing me by the hour and had no interest in my well-being. He said if this went to court, it would be ugly, and did I really want to do that to the family? I looked at him steadily. "Dennis," I said, "your attorney received our response to the settlement offer. There is nothing to discuss today that hasn't been communicated in writing." He leaned forward. "You need to think about what happens when you can't live alone anymore. Who do you think is going to take care of you?" I said, "I am 75 years old and I live alone just fine." I was ready for this conversation. I stood, I picked up my coat, and I left. He did not follow me out. The hearing was held on a Thursday in April at the Roanoke Circuit Court. The courtroom was smaller than I expected. Fluorescent lighting, pine-paneled walls, 6 rows of wooden benches behind a low rail, and a long table at the front where both counsels sat with their documents and their water bottles. Judge Howard Blackwell presided from an elevated bench, a direct, methodical man in his early 60s who had, according to Patricia Anholt, a well-established record in property and probate disputes. Patricia Anholt presented first. She entered the deed in my name, Exhibit A. She entered the probate order from 2017, confirming sole title transfer. Exhibit B. She entered 7 years of tax records, paid from my account. Exhibit C. She entered the homeowner's insurance policy. Exhibit D. She entered Dennis's 2022 letter, describing himself as a temporary guest. Exhibit E. She entered Gerald's 2014 letter to Dennis. Exhibit F. And she read it aloud in full, clearly, at the judge's request. Then she presented the quitclaim document Dennis had produced. She entered the sworn affidavit from the Roanoke County clerk confirming that no transfer had been recorded and that the document did not meet the statutory requirements for a valid deed transfer in the Commonwealth of Virginia. She entered a report from a document examiner who had reviewed the quitclaim form and identified inconsistencies in the notarization block, specifically that the notary's seal number did not correspond to an active commission in the state. Records at the time the document was purportedly prepared. Barry Fenwick argued on Dennis's behalf that the quitclaim document was a preliminary draft, not a coercive instrument, and that Dennis's long-term residence in the house established a form of equitable interest. Patricia Ann Holt responded with a single exhibit, Exhibit G, which was a certified bank statement showing that Dennis Ray Whitfield had made no financial contribution to the property, in any form, for the entire period of his residence. She asked that the court affirm my sole ownership and dismiss any equitable interest claim in its entirety. The judge had questions. He asked me 3 of them directly, from the bench, in a quiet, even tone. He asked whether I had ever verbally promised the house to Dennis. I said no. He asked whether Dennis had at any time paid rent. I said no. He asked whether I had been aware of the quitclaim document before the night Dennis presented it to me. I said no. Judge Howard Blackwell reviewed his notes for approximately 4 minutes. Then he ruled. He found no basis for equitable interest. He found the quitclaim document legally invalid on multiple grounds, including defective notarization and absence of grantor consent. He entered a declaratory judgment confirming that Margaret Eleanor Whitfield held sole, unencumbered title to the property at its full appraised value of $680,000. He ordered Dennis Ray Whitfield to vacate the property within 30 days of the original filing date, which had already passed, and awarded attorney's fees to my counsel. I did not look at Dennis when the ruling was read. I looked at Patricia Ann Holt's hand on the table next to me, and then I looked at my own. My hand was steady. I did not cry. Dennis Ray Whitfield was gone from my house before the court order required it. He took what he had brought, the 2 duffel bags and the box of books, and he left a key on the kitchen counter without a note. I did not enter the spare room for 3 days. When I finally did, I opened the window and let the air through. And then I repainted the walls a shade of pale green that I had always liked and never used. I went back to my garden in the first week of May, after the last frost, and I planted the same things I plant every year: tomatoes, rosemary, a row of sweet peas along the south fence. I had the front porch boards examined, found 2 that had softened, and had them replaced with new pine. The house smelled like paint and cut wood and wisteria all at once for a full week, and I found I did not mind that combination. Pauline came to visit in June. We sat on the wraparound porch in the evenings, and I did not talk about the case, and neither did she. One evening she said, simply, "I'm glad you didn't sign it." I said, "So am I." We left it there. We did not discuss Dennis, but the silence between us on that subject was not cold, it was careful. Careful is not the same as finished. But it is, for now, enough. I have thought a great deal about what I want to say to you about all of this. And the truest thing I have come to is this: a deed is just paper. The house is not paper. The house is 31 years of early mornings and late evenings, and one man's hands on fresh-cut lumber and the smell of wisteria coming through a window I chose. No one can file a document that takes that from you. What they can do, what Dennis Ray Whitfield nearly did, is make you believe that your age is a liability and that your grief is a forfeit. It is neither. I am 75 years old. I still plant my own garden. I still pay my own taxes. I still know, without hesitation, when a piece of paper in front of me is meant to diminish me. And I know, because I lived it, that the correct response to diminishment is not silence and not fury. It is paperwork. It is precision. It is a very good attorney. I want to ask you something before I go. Tell me in the comments, have you ever found yourself in a room where someone used your love against you and had to decide, very quietly and very quickly, how much of yourself you were willing to give away? I would like to know. I think many of you would. Until next time, dear listeners, take good care of your houses, and I mean that in every sense of the word.